Hi everyone. Welcome back. This is the last final part of the lecture on psychiatric injury claims. So you will recall that we had, sorry, let me get to the right bit. Okay, here we are. So you will recall that we'd looked at the aftermath, the notion of immediate aftermath after Alcock. And we looked at the different approaches before Alcock, the restrictive approaches immediately after, the slightly more flexible approach that was taken in Atkinson, and then the restriction being put on again, or the limitation, being placed again in terms of Taylor and Novo. So let's just look or spend a little time looking at how many secondary victims are now succeeding within a hospital environment in terms of those Alcock controls that we've seen in operation earlier. So let's kick off with Liverpool Women's Hospital and NHS Foundation Trust. So in Liverpool, the respondent was an experienced ambulance driver, and his wife underwent emergency treatment at the appellant's hospital. He had claimed as a secondary victim for the distress that he suffered whilst witnessing her suffering. They succeeded at first instance. However, the hospital appealed, and that appeal was successful. The court found that this was not a case in which there was a sudden appreciation of an event. What the claimant saw on these two occasions was not horrifying by any objective standards. What is required in order to found liability is something which is exceptional in nature. So it confirmed, what Liverpool did was confirmed a strict approach to the control mechanisms for secondary victims, particularly in cases where or which concern clinical negligence. So the case of Barisha and Stone. So the claimant, Ms. Barisha, was informed by police that her partner had suffered a serious accident at work. She arrived at the hospital 5 hours after the accident to be with her partner, who was then on a life support machine, having suffered a severe brain injury. She was at his bedside continuously for around 36 hours, thereafter holding his hand and observing his face swelling and becoming disfigured, until with her agreement, the life support was switched off and he passed away. It was held that Ms. Barisha had witnessed the consequences of the accident, but not the immediate aftermath of the accident. She cannot establish the control mechanism of proximity in sight and sound to the accident or of the immediate aftermath, and thus the judge dismissed her claims. In Wild, the claimant, Mr. Wild, was present with his wife at hospital on their baby's due date, and they unfortunately discovered that their unborn son had died in the womb due to the hospital's negligence, and that caused Mr. Wild's psychiatric injury. The court held in dismissing the claim that the claimant did not satisfy the control mechanisms in Alcock. It was not enough for him to have been witness to the manifestation of the consequences of the defendant's negligence, i.e. the retrospective discovery that the baby had died in the womb. That does not equate to actually witnessing a horrific event leading to death or serious injury. And also there was no sudden shocking event as the law requires. Here, there was a gradual realization that medical staff could not find the baby's heartbeat and mounting panic for the father. So the fact of the realization, the discovery that the son had died in the womb did not meet or satisfy the Alcock controls. There was no witness of a horrific event leading to death or serious injury. So there was no shocking sudden, shocking event as the law requires. In the case of Brock, the Court of Appeal held that grief and loss caused to a parent when a child dies is insufficient to found liability. There has to be a traumatic experience akin to witnessing an accident. And in Shorter, it was held that a gradual accumulation of events was not the same as a horrifying event that caused a violent agitation of the mind. So it goes back, these cases so far are staying very true to the Alcott controls in terms of what constitutes immediate aftermath, in terms of the sudden shocking event, and also in terms of something having to be immediate and sudden rather than gradual, so over a period of time. In the case of Calderdale and Huddersfield NHS Foundation Trust, the infant claimant suffered a brain injury during her protracted birth. Her mother and grandmother sustained psychiatric injuries following sight of the baby, who was born in an extremely poor condition. Justice Goss held and accepted that the mother was a primary victim. This was on the basis that at the point at which the negligence occurred and the onset of her PTSD, the infant was not a legally separate entity from the mother and was still in the birth canal. Therefore, the mother was a primary victim and was entitled to damages for her injury. In the alternative, because the court also discussed the alternative, the mother was a secondary victim, as was the grandmother, and satisfied not only the Alcott criteria, but also what they described as the new criterion set out in Liverpool Women's Hospital NHS Foundation Trust, that there must be a sudden appreciation of an objectively horrifying event. Justice Goss found that the sight of the baby satisfied that criterion, and the judgment was accordingly entered for all three claimants, so the mother, the grandmother, and the infant claimants as well. So Huddersfield and Calderdale NHS Foundation Trust identified a new criterion that had been set down in Liverpool Women's Hospital, and that was of the sudden appreciation of an objectively horrifying event. So that subsequently adds or expands, to the notion of immediate aftermath and what constitutes that. And in Werb and Solent NHS Trust, the claimant was subject of a strikeout of their application, being struck out. This was refused where second claimants had committed suicide 2 days after being discharged from a psychiatric hospital. The strikeout of the application was refused because there was an arguable case of close proximity, as the suicide was the event, not the release from hospital too early. So the notion of what constituted proximity was the subject to the discussions in Werb and Solent NHS Trust. So returning back to rescuers and the case of White, I've touched on this briefly, but I'll just go over it again for you. So until the case of White, rescuers have been accorded a special position. Since as a matter of policy, the courts had wished to encourage rescuers. So rescuers had always been thought of as primary victims. The argument is that where an injury is foreseeable, then rescue is foreseeable, and the decision of a person to attempt to rescue is a natural impulse which does not constitute a novus actus. So in Chadwick, 1967, Mr. Chadwick tried to bring relief and comfort to the victims of the Lewisham train disaster in December of that year. His widow claims nervous shock, saying that it had eventually led to the incident had led to his death, and because of that, she claimed nervous shock. And it was held that where an accident is of a particularly horrifying kind, and the rescuers involved with the victims in the immediate aftermath, it may be reasonably foreseeable that the rescuer will suffer psychiatric injury, therefore putting the rescuer in the position of the primary victim. In Hale, a fireman was able to claim successfully for PTSD that he suffered following the King's Cross fire in central London, though bystanders who suffered shock at the scene of disasters will not be found to be successful in any claims. So all of these rescuers that were able to successfully claim in terms of psychiatric injury all claimed before the case of White, and they were all identified as being primary victims. Now that changed in terms of White, where, as you know, having covered this earlier, the House of Lords found that police officers were secondary victims and not within the range of foreseeable physical injury. The law on the recovery of compensation for pure psychiatric harm is a patchwork quilt of distinctions which are difficult to justify. The only sensible strategy for the courts is to say thus far and no further, to leave any expansion or development in this corner of the law to Parliament. The ordinary person would think it wrong that policemen should have the right to compensation for psychiatric injury out of public funds, while bereaved relatives are sent away with nothing. However, if a professional rescuer can establish that they are exposed to danger and the risk of physical injury, or reasonably believe themselves to be so, they may qualify as a primary victim. Note, when I spoke about the case of White, I also highlighted to you, sorry, I'm just trying to find the case name. Bear with me as I look back through my notes. Talk amongst yourselves. I can't find it now. But back in your back in these PowerPoint slides where I previously mentioned the case, here it is, Dinesh. That's it. So whilst White sets down that police officers are secondary victims, so rescuers in terms of their capacity with what they do are secondary victims, if a professional rescuer can establish that they're exposed to danger and the risk of physical injury, or reasonably believe themselves to be so, they may qualify as a primary victim. On slide 29, that's what happens where the case turned on its own facts, and that's the case of Donarchi and the Chief Constable of Greater Manchester, which we went over earlier on. In terms of note here, or a note to add, Lord Gough dissented with the majority judgment. So then what is the positioner of rescuers following the case of White? So in Cullen and the London Fire and Civil Defence Authority, the claimant was a firefighter who suffered psychiatric injury after witnessing two colleagues trapped inside a burning building. Attempts at rescuing them have failed, and the defendant claims, and this case mirrored that of White, which we've just discussed. The court held that it could be argued that the claimant, in his rescue attempt, was exposed to danger or reasonably believed he could be subject to physical injury, and therefore he was found to be a primary victim. the court decided to follow the obiter statements of Lord Gough. Remember, I just mentioned that Lord Gough made a powerful dissenting judgment in the case of White. In Monk against Harrington, this was a man who assisted an accident, assisted at the scene of an accident. The court held that the claimants who had provided assistance to victims of a construction accident was not a primary victim. Although the claimants had provided significant help to the injured men that was neither peripheral or trivial, he could therefore be regarded per se as a rescuer, but the evidence showed that it was improbable that he believed that in rushing to the scene, he was putting his own physical safety at risk. Nor could he show that he was an unwilling participant, as there was no reasonable basis for a genuine belief that he might have caused the accident. Accordingly, it could not be said that it was reasonably foreseeable that a person in his position would have suffered psychiatric injury, and therefore he was precluded from recovering damages in respect of those injuries. So therefore, in terms of rescuers, White has changed the landscape from the blanket acceptance that rescuers are primary victims, and therefore there is now consideration that rescuers are secondary victims. However, if a rescuer can establish they're exposed to danger and the risk of physical injury, or reasonably believe themselves to be so, then they may qualify as a primary victim. So what happens then when psychiatric injury is sustained in a very different situation from that that's envisaged in Alcock? Remember, Alcock was psychiatric injury caused through what happened at Hillsborough, but the claimants had watched the events unfold on television. So in W against Essex County Council and another, it was said that the categorisation of those claiming to be included as primary or secondary victims is not, as I read the cases, finally closed. It is a concept still to be developed in different factual circumstances. So in terms of the future of psychiatric injury, there is a school of thought that suggests that actually, depending on the factual circumstances of each case, there could potentially be a movement in terms of the categorisation of primary or secondary victims. So what then is the future of psychiatric injury claims? Well, the law is thought to be in need of urgent reform, as I'll go into in a minute, to remove the need for injury to arise from a single shocking event. Sorry, let me read that again. The law is thought to be in need of urgent reform to remove the need for injury to arise from a single shocking event. So to get rid of the need for immediate aftermath to be subsequent to an immediately shocking single situation, single event. Can it be right that a person witnesses a loved one die in a single accident and they can bring a psychiatric injury claim, but a widow who watches their husband die from an asbestos-related disease cannot claim? And the cases that you have in front of you just show the diversity in approaches in terms of successful or unsuccessful psychiatric injury claims. So in Farrell and Merton, the mother suffered nervous shock when seeing her newborn baby being operated on, and the judge was willing to satisfy the claimant as a secondary victim and a potential primary victim. In McLaughlin, which we heard at the very beginning, the claim was allowed as a secondary victim, had come upon the immediate aftermath of the incident. In North Glamorgan NHS Trust, a shocking event was not confined to a single moment in time. The 36-hour period prior to her son's death could be classed as a single horrifying event. In Taylor, it was found that death was the relevant incident at the trial, but the Court of Appeal reversed this following the decision in Alcock. In Liverpool Women's Hospital NHS Foundation Trust, they applied a strict approach in terms of secondary victims and developed that new criterion that I spoke about just a moment ago. And in a minor, they followed the decision in Liverpool, and there must be a sudden appreciation of an objectively horrifying event. That was the new criterion that was identified in a minor that had been set down by the decision in Liverpool. So what does the future hold then for psychiatric injury claims? Well, it appears there is some flexibility, but potentially this has been extinguished. There might be flexibility in terms of situations that have not previously been encountered. Some flexibility around the determination of primary victims, if you look at some of those medical negligence cases, and also look at rescuers in terms of whites, and maybe if rescuers can prove that they were in belief, or they were at risk of physical injury, or they believed they were at risk of physical injury, then they potentially could become primary victims. And component events. So going back to North Glamorgan, that 36-hour period was classed as a single horrifying event, not just one incident that happened at, maybe in 1 hour or over a space of 2 hours. It was over the space of a number of hours there. But any major expansion of liability will be left to Parliament. It still remains that a shocking event must be exceptional, it must be sudden, and it must be horrifying. In terms of duty of care, it's worth remembering that there are special rules for establishing a duty of care for psychiatric injury within the realms of negligence. The Law Commission has made proposals for a reform in terms of liability for psychiatric illness. That's the Law Commission proposals there. The creation of a statutory duty of care to be superimposed upon the existing elements of the tort of negligence. This would retain the control mechanism of a close tie of love and affection. It would abolish the requirements of proximity in time and space and the method of perception, and create a fixed list of relationships with an irrebuttable presumption of close tie of love and affection. And it would be open to others to adduce evidence of such a tie. And the sudden shock requirement would also be abandoned. That was the proposals by the Law Commission. The government response to those proposals, in 2007, they issued a consultation paper, but ultimately they rejected the Law Commission's recommendations and concluded that it was preferable to allow the courts to continue to develop the law on liability for psychiatric illness rather than attempt to impose a statutory solution. I'll leave the question around whether that's satisfactory to you. In terms of some considerations you might want to give is whether the current law is sufficiently consistent, or whether it's insufficiently consistent but allows primary and secondary victims to develop on a case-by-case basis. They're just some points that you might want to consider. In October 2015, a private member's bill was put forward, the Negligence and Damages Bill, which sought to impose a statutory duty of care, suggested abandoning the sudden shock and proximity in time and space requirements, suggested a substantial expansion of the list of relationships to which there should be an irrebuttable presumption of close tie of love and affection. However, the bill was not debated, would not make, and still will not make any further progress. It did follow the Law Commission recommendations, but unfortunately fared no better than the Law Commission did. So as it stands at the moment, there is no plan to impose any statutory duty in terms of liability for psychiatric injury. Okay, so that concludes the substantive bit of the lecture. In terms of problem solving, I will leave these slides up here for you to go through, but the question that you are answering in your seminars is question 1, and that is an essay question. So you need to, and I'll put this on Moodle as well, you need to answer question 1 of your seminar booklet for psychiatric injury, which concerns a critical assessment of the court's approach to claims for psychiatric injury in light of a statement that's been extracted from the case of Alcock. And it also requires you to consider the Law Commission's recommendations for reform of this area and the government's response. Now, of course, I've given you this brief overview of that, but there is nothing stopping you going and finding that paper from the Law Commission and obviously reading a little bit more around what that government's response is. But in terms of a problem question, it's about the same approach to a problem can also apply to an essay. So your discussion should start with the acknowledgement that actually you have to have recognition of a psychiatric injury. Also, some determination or some discussion around why there is limiting factors for recovery of damages in psychiatric injury. That's very much at your introduction and beginning stage of any essay writing in terms of this area of law. A primary and secondary victim discussion is needed. Remember, the approach that's on the screen is to problem solving. I'm showing you how this approach can be adapted for an essay. So you've got the notion of primary and secondary victims in Page and Smith. You've got the primary victim within the range of foreseeable harm, a secondary victim outside the range of foreseeable physical injury, and obviously the consequences of that, and why there is a fear of floodgates, and the fact that the Alcock controls need to apply. For secondary victims, as I've just said, you have the Alcock considerations, the close tie of love and appreciation or affection, the proximity to the accident or its immediate aftermath, which was sufficiently close in time and space, and seeing or hearing the accident or its immediate aftermath with your own senses. That area, in terms of primary and secondary victims, has been problematic for rescuers. Immediate aftermath and what that means has also been problematic. And there can also be a discussion around the development of the categorization in terms of primary and secondary victims, and also the development of recent case law before you go on to discuss the Law Commission proposals. That's the end of your lecture for psychiatric injury. I'm really sorry that I couldn't deliver it in person. What I advise you to do is to listen to all 4 parts of this, maybe run through it all at once first, or if you don't fancy doing that, and in terms of listening to them all and then going back and making notes, listen to each one individually, make some notes, listen to the recap at the beginning of each section of this lecture, which links what you're about to listen to what happened previously. I will also put up over the weekends a more detailed PowerPoint that maybe breaks down the Alcock controls with a bit of discussion, or which shows you, signposts you to where you can find that discussion, and also how that Alcock control discussion fits into White and subsequent case law developments. Okay, well, thank you very much. I hope you understand why I kind of broke these down into bite-sized chunks for you, in terms of instead of maybe doing something all at once. And I hope to hear from you soon on either email or yes, predominantly email, I guess, in terms of maybe being sent some practice questions, or the practice questions for occupiers liability, and the one that you're doing here for the seminar, which is question 1 on psychiatric injury. Okay, thank you very much. Take care of yourself, and goodbye.